Mihir Desai, Bombay's much-loved lawyer who has been fighting court cases on behalf of the marginalized on issues of human rights, advocates for petitioners on the right to privacy and the Aadhaar issue, and has been a legal counsel to the International People's Tribunal on Human Rights and Justice in Kashmir.
I'm sure a lot of, or at least some of you would rather that I talk about the corruption in the Supreme Court, the Chief Justice, or whether Justice Daya died a natural death or was he murdered. But that for a later time. I was asked to speak on the right to privacy judgment and its linkages to the culture of fear, or whether it will affect, it will not affect. But before I do that, let me just say one thing which I thought in continuation of what has been talked about here, I wanted to just highlight. Somebody sometime back, was talking about Jai Shah's case. I was representing Rubabuddin, Mr. Amit Shah's son. Amit Shah's, I'm sorry. Apologies. That's fake news. So I was representing Rubabuddin, and the matter came to High Court from Amit Shah's discharge. Now I have handled cases, number of cases where after a case starts, people want to settle, people want to withdraw. They come to court, they say that now we have worked out whatever disputes we had, we want to withdraw, and they go off. Rubabuddin came to court and said he wants to withdraw. Yeah. I have never in my life seen a person shivering in court when he says that I want to withdraw. I've never seen it. I mean, he was literally shivering, he was about to collapse just to say that I want to withdraw. And obviously I knew why he was shivering. Okay? That was the kind of fear he was, it had nothing to do with matter having been settled, except in a way in which law doesn't recognize. But this is what this is when you realize that the kind of fear which can be inflicted on people just to withdraw cases. And that is what I want to start out with. But coming back to what I'm supposed to speak on, that is the right to privacy judgment, and whether and in what extent it will impact or affect the culture of fear. At the outset, I want to say that the right to privacy judgment is an excellent judgment of the Supreme Court. I mean, I guess everybody is aware about the fact that the judgment was out. 9 judges unanimously held that every individual in this country has a right to privacy. It started from, of course, the Aadhaar case, where a lot of people, including, we have also challenged Aadhaar. Some of our petitioners are present in court, are present in the audience here. This is what happens when you're a lawyer and always trying to...
It's a people's court.
People's court. Okay. Very well, court nonetheless. So Aadhaar was being challenged in Supreme Court, and one of the grounds of challenge was that it violates the right to privacy, that the government will know, and obviously therefore the big corporates would know, that which hospital I visit, which temple I visit, which lawyer I visit, which doctor I visit, which chartered accountant I visit, what all is there in my, everything about my intimate life. Okay? Everything the government would, state would have control over, state would know. So it's completely against the right to privacy. That was the argument. And the Attorney General gets up and says that there is nothing like right to privacy in this country. Okay? You don't have a right to privacy. And therefore, ultimately the matter was referred to a larger bench. And please remember that in 53 and 61, there were two judgments of the Supreme Court which indicated that there is nothing like right to privacy. But since last 35 years, the Supreme Court has proceeded to decide various cases on the footing that there is a right to privacy. So right to privacy was recognized. Anyway, finally, the matter was argued and the Supreme Court held that the right to privacy exists. Okay. And it held it in three ways. One is the right to bodily integrity, that every individual has a right to bodily integrity. Second was the right to informational autonomy, that is, my information about me should not be divulged to somebody else unless I consent to it. That was the second part. And the third was the question of decisional autonomy. That is, I have a right to make choices concerning my life over which the state or anybody else has no control. This is a three-part system by which the Supreme Court held that yes, you have the right to privacy, and if your right to privacy is violated, it would amount to violation of a fundamental right. What is surprising? Not surprising really when looking at the Supreme Court today, but this judgment, the central judgment, 6 judges, when 4 judges meet normally in Supreme Court, they write 6 judgments. Here, of course, we were spared with that, and 9 judges came out with 6 judgments. Okay, but there are 6 judgments. Everybody saying the same thing, but 6 separate judgments. So it goes into 540 pages. Anyway. The main judgment, the central judgment, was given by Justice Chandrachud, a very well written, very well researched judgment, saying all this. After a month and a half, the same Justice Chandrachud is hearing Hadia's case. Okay? Now, we have to realize that it's one thing to pompously announce that this is your fundamental right and that is your fundamental right, and all that kind of thing. It's another thing when it comes to practice. Okay? Now, I've never understood this logic that this woman has got married, and despite 9 months of incarceration at her parental home, she insists on saying that she's married of her free will. She is converted of her free will. Why? Where does the NIA come into picture? And the Supreme Court, while granting some liberties to her by saying you can go to college, and the Supreme Court will decide who will go to college, who will go to school, who will go to... But anyway, by granting her that liberty, it's still not stopped the NIA probe. Where is the question? What happens to her privacy? And what happens to her privacy? It's similarly, UID, the Supreme Court, while passing the judgment in the privacy matter, says very clearly that if it comes to beneficial schemes for people, the government can always insist on the right to privacy being violated so that the funds of the government are not wasted. Indicating thereby, the UID case is yet to be heard, but indicating thereby that UID can definitely be made mandatory if you are giving out some sums. So that indication has already come. Okay, if you ask me that because of this right to privacy judgment, are things going to dramatically change? They will possibly change in respect of the LGBT community. Possibly, because judges have strongly come out against the existing judgment of the Supreme Court, which criminalizes homosexuality. So that it might affect. But otherwise, whether it will, because you have number of cases coming up which deal with right to privacy. Beef ban case. I mean, we were arguing that case in the Bombay High Court. Now it is pending in Supreme Court. It was such an effort because you are just saying, I mean, forget everything. Forget whether you can slaughter, not slaughter, etc. I am saying that if I am getting beef, somebody goes to Goa, gets beef, comes to Bombay and eats it. The law said that no, that's a crime, you can go inside jail. Okay? So the eating, and when you are talking about privacy, privacy includes my right to eat what I want. Okay? Yesterday somebody was speaking about it. So beef ban is one aspect which is important. The other thing, which UID, of course, UID is going to be a huge challenge. I don't know how many of you have UIDs. A lot of you do not have UIDs, and out of principle, I assume. But Aadhaar cards, the case concerning Aadhaar card is going to determine to a large extent, okay, how the privacy doctrine is going to play out in practice. Okay. Similarly, I mean, 377, the marital rape case which is going on, various other cases. But the point which I wanted to make was that there are, no matter what judgments the Supreme Court gives, there are two caveats which we must remember. First, as I already mentioned, that it's one thing to propound right to privacy, and I would be much more happy that I am happy that right to privacy has been recognized as a fundamental right, rather than it not being recognized as a fundamental right. But it's one thing to propound it. Second thing is how it works out in actual cases is a separate aspect. The other thing is that law normally, or judgments normally, what do? They provide some kind of a benchmark for people's behavior, a normative benchmark as to how people should behave. They also provide some kind of a moral benchmark as to how people should, how society should act, how state should act, how people should. But when the state itself indulges in encouraging violation of the law, okay, when the party in power itself indulges in violation of the law, as it is happening right now with the lynchings which we are talking about, because no law says you can lynch. Okay, so when the state itself encourages, okay, the judgments of the courts, okay, do not really make much of a difference to people's lives. Okay. I am a lawyer, but I have my own doubts about efficacy of the legal system and judiciary. I'm too old to change my profession now, so I can't do that. But that's the reality of how the courts function. The other thing which I wanted to just quickly mention, that nowadays when we are talking about culture of fear, we have to also recognize that one way in which fear is brought about is by allowing crowds together, lynchings to happen, this, that, etc. The other way is by state selectively using the law to throttle people and people's struggle. Look at what happened to Lawyers Collective, Indira Jaisingh's organization. Their FCRA was cancelled. Look at what happened to Tisra Settlements. Okay. FCRA is cancelled, about to be, I mean, she was nearly put in behind bars because they were opposing. Look at what happened to people who are fighting against nuclear. So you using the law, and this state, present government is very smart in using the law. Look at what happened to Greenpeace. Fortunately, neither of these three, whether you talk about Greenpeace, whether you talk about Indira, or whether you talk about Tisra, have buckled down, and they carry on fighting, and they fight with added vigor. If you have, but remember, this also has chilling effect on other people. It's not just that you are attacking a Tisra or Indira. Okay? They might fight back, but there will be a lot of others who will get scared and say, "Jane, why should we get into all this?" Let's just carry on with our task in our small way, rather than taking on the government. So the chilling effect which this has, even on a lot of people who want to fight, is something which we need to look at. We need to, but the positive thing is, despite all this, despite this culture of fear, and that's what others also mentioned, that despite this culture of fear, we are in a situation where a lot of people are fighting back. People are not, yes, the struggles today are much less radical than one would like them to see, but they are happening. People are not cowing down under pressure, they are fighting back, and I only hope that this continues. I am sure it will continue, and this is one small step in that direction, and I hope you carry on with this. Thank you very much.